Good morning. This is the court reporter. I am having problems. Are you guys able to hear me?
I can
can't
hear
get
you
into my
fine.
court reporting computer and we're trying to work on it. I don't know if you can give me a couple minutes.
We can give you a couple of minutes if that would help. We'll
I
just
don't hear anybody. I'm sorry.
Yeah, can you hear me, Ms. Diaz? Uh-oh.
Yeah.
I'm not on mute.
You can't hear me?
I can hear you, but I don't know if you can hear me.
I can hear you now. That's
All
the
right.
IT people calling me. So I'm going to mute myself.
All right, we'll pause for a couple of minutes for the benefit of the court reporter. Our electronic recording is proceeding, but please just stand by and we'll do it that way.
Mr. Lilly, while we have a moment, this is Sam Bivens from Downey Brand. I just wanted to say that I'll be appearing on behalf of San Bernardino Valley Municipal Water District, along with my colleague, Holly Tokar.
Okay. And Mr. Bivens, it's probably good if you put that on the, we have it on the electronic recording, but when the court reporter is going, you might as well put it on that record too. So just stand by and we'll do that.
Will do.
Okay, so I have a suggestion. I can't get it to work. They might have to replace me. But if you guys want to go ahead and start, and I will get it from the video.
All right, we will go ahead and do that.
Oops, I'm sorry.
You.
I turned my sound off so I could talk. So is everybody okay with that suggestion?
Yeah, I'll just say that maybe you should tell us, Ms. Diaz, how long do you think it'll be before either you or a backup will be able to start doing the transcribing?
I'm not sure. I'm rebooting again. The IT person is researching and supposed to call me back in 2 minutes, and they're looking for another reporter.
All right. So, well, unless anyone has any objection, I think we will proceed. We do have our electronic Zoom recording, which has both video and audio, and we also have the YouTube live recording. So we do have a pretty good backup that the court reporter can make the transcription from for the first part of this proceeding today. And as I've said before, my view is that the Zoom recording is in fact the official recording for this proceeding. In any event, I certainly have no objection to the court reporter recording this and preparing a transcript, which if is submitted to the Administrative Hearings Office, we will add to the record. But anyway, that's my view. So does anyone have any objection to our proceeding under that approach? Okay, so hearing none, we will get started and proceed. And even more important than ever, everybody please speak slowly and carefully and one at a time to help the court reporter later obtain or prepare a transcript from this proceeding. So Mr. Bivens, why don't you go ahead and, well, let me back up. I'll go ahead and first do my introduction and then you can give your statement again. So my name is Alan Lilly. I'm the presiding hearing officer at the State Water Resources Control Board's Administrative Hearings Office. And this is a proceeding today. We are still doing the parties' cases in chief in the hearing on the prosecution team's draft cease and desist order against BlueTriton Brands Incorporated, which I refer to as BlueTriton. I'm not going to ask for appearances. Everyone's name does show up on the Zoom recording, and you've all entered your appearances before. With the exception of Mr. Bivens, I think you've been in some of our hearings before, but please go ahead and enter your appearance today, along with, and for Ms. Tokar as well.
Thank you. I have, but I appreciate the opportunity. Sam Bivens, Downey Brand for San Bernardino Valley Municipal Water District, along with my colleague, Holly Tokar.
All right, and good morning to both of you.
Good morning.
So before we get started with testimony, I just want to make sure I have everything in order for what's pending. I have pending still to prepare a ruling on the prosecution team's motion to quash BlueTriton's subpoena ducis tecum. I have pending a ruling on the Center of Biological Diversity's requests for what I'm just going to call BlueTriton modeling information. Did request to spell that in more detail. I have sent out a revised hearing notice or amended supplemental hearing notice, I think is the terminology, and we now have the site visit set for February 16 and 17. I'm still waiting to hear back from the San Manuel Band of Mission Indians regarding permission to for us to go on their property. I certainly will let you know by email when I receive that response. And my plan is to prepare a more detailed notice of the site visit, which will have the schedule and itinerary and various cautions regarding the facts that we're going to be on. At least part of it will be hiking on somewhat rough terrain, is my understanding. I've never been there before. And then also BlueTriton, Mr. Lawrence provided some information on the helicopter safety rules, which I will include in the detailed notice. So those are the matters that I still have under submission or pending for my office and me to prepare. I do have pending, I sent a letter to Mr. Donlin on January 26th, requesting BlueTriton provide some additional information. I just saw this morning that Mr. Donlin responded with a letter on January 30th, which of course we will add to the record, but I haven't checked, but he did serve everybody on the service list as well. So we will talk about that. Mr. Donlin has requested a status conference on that. He said basically on whatever the date is at the end of our hearing, probably Wednesday. So we will, I think that's a good suggestion that we discuss that once we finish the cases in chief that we have set for this week. That will give me a chance to read this, give everyone else a chance to read Mr. Donlin's letter, and we can talk about that. And then Mr. Donlin, I did have also on my list, your office has been good about providing copies of some of the groundwater extraction notices that were missing from the State Water Board files. I think your last submission said you potentially may have some more notices. What is the status of BlueTriton's response to that request?
Mr. Lilly, to my knowledge, our last response was to provide additional extraction reports that we were able to locate in BTB's files or otherwise. There are still reports that have not been located. I don't recall the date that we submitted that updated report, but it was either last week or the week prior.
So are you still looking for the reports that are still missing? You meaning you and BlueTriton?
We are, Mr. Lilly, but no guarantees that we will locate anything else at this point.
Okay, thank you. Yeah, it looked like 1989 was a bad year. That was the year that I think they were missing for almost every single report. But then notices. For some of the other notices, there were certain years, I should say there were some other years missing for a few of the notices. But anyway, I think between San Bernardino Valley Municipal Water District and BlueTriton, we're putting together a lot of the notices that were missing from the Water Rights Records Unit. So I appreciate that. So I also did receive the Story of Stuff project table of corresponding exhibits. That shows the correspondence between some of their exhibits and some of the prosecution team exhibits, which I appreciate. Thank you. And I also received from Ms. Fry her table of corresponding exhibits, which shows her which ones of her exhibits correspond to Story of Stuff exhibits or prosecution team exhibits. So with that, before we get started, are there any other preliminary matters that anybody believes we need to address or should address this morning? Ms. Doty, your hand is up. Thank you. Please go ahead.
You had asked before that we coordinate with Mr. Lowe and Ms. Fry to try to make today and perhaps tomorrow and the next day go as efficiently as possible, and we did. And I would like to propose that Ms. Fry go first today, followed by Story of Stuff, followed by Mr. Lowe, and they have agreed to that.
Oh, okay. Well, that's certainly a curveball that I was not expecting. I've had all your exhibits here ready to go. Is there some reason why you want to do that?
Just because of the testimony that Ms. Fry has proposed in her evidentiary statement. I just think that it makes sense in terms of storytelling, understanding what's going on for her to go before the content that Mr. Lowe will be asked about in direct an hour.
Okay. All right. Well, so you wanted to have Ms. Fry go first, and then did I hear Story of Stuff second or Mr. Lowe second?
Well, Story of Stuff, but we'll have Mr. Lowe's direct, his substantive direct. If you'll recall, Ms. Fry in our case in chief is primarily authentication of documents. We had our evidentiary statements were Ms. Fry on authentication, myself on authentication, and then Mr. Lowe had substantive testimony. Ms. Fry, in her personal case, had substantive testimony, and hers largely deals with history of the area. So it makes sense, I believe, for her to go first. And then in our case in chief, as we noted before, Mr. O'Heaney would give the opening statement, and then I will do the direct examination of Mr. Lowe. And then if Mr. Lowe has anything remaining, then he has his time, but hopefully we will touch on most things in the direct, and that will be more efficient for everyone involved, I hope.
Right. So I understand your proposal. Before I rule on that, I see Mr. Donlin and Ms. Grady's hands are up. So Mr. Donlin, you're on the far left on my screen, so go ahead.
Thank you, Mr. Lilly. Going back to the outstanding and pending actions before you, do you have a time frame by which you expect to rule on the state's motion to quash our subpoena? We would have liked to have had that ruling, obviously, before we cross-examined the prosecution's witnesses. But that's been pending before you for some time now, and we would like a ruling on that. We think that's an important document that we've made.
Well, and the answer is I will get to it as soon as I can. I certainly plan to get to that before the rebuttal phase of this hearing begins, which is, I think, in about 4 weeks, hopefully well before then. And if it turns out that I deny the motion and therefore the prosecution team has to produce those exhibits, then I think that is something you can address on rebuttal, and as necessary, we can have the prosecution team witnesses appear during that part of the hearing. So I don't think you'll be prejudiced by that, but that is my plan. One of the reasons I haven't gotten to this sooner, frankly, is I've gotten a lot of other motions and requests that required more prompt action. Excuse me, and working with the San Manuel Band has taken a fair amount of time regarding the site visit. So that's to that sooner, but I certainly am aware that is pending. So Ms. Grady, your hand is up.
Yes, one of the other issues that remains outstanding, which is relevant to where we're headed this morning, is BlueTriton Brand's motion in limine and objections to the testimony proffered by Ms. Fry, Mr. Lowe, and Story of Stuff. Have you had opportunity yet to review their written testimony in relation to the motion in limine?
I have reviewed all of their written testimony, but you'll have to remind me, what exactly did your motion in limine say as regarding them? If you can just give me a quick summary, and if necessary, I can take a look at that. I'm sorry if that was something that was still pending for ruling, but thank you for reminding me.
Yes, you had deferred on that portion. In short summary, we had objected to Ms. Doty's written testimony, which appears to be a declaration proffering a range of documents without any testimony. Apparently, she was not identified as a witness and proffered no testimony to establish the relevance or discuss the purpose of the documents being offered. She simply provided a declaration detailing where she obtained them. And with Ms. Fry.
Okay, I'll go back. Yeah, go ahead. Tell me about Ms. Fry.
Ms. Fry had proffered two sets of testimony, one written testimony for herself individually, which is largely, I would characterize as expert type opinion testimony without any foundation. She is not offered as an expert and has proffered no documentation as required by your order, the notice of hearing order dated November 17th, which establishes the process for expert witnesses to proffer testimony. Most of her testimony is far beyond the scope of that which would be allowed for a lay witness under the rules of evidence, California Evidence Code, section 800 discusses lay witnesses, and if they're not testifying as an expert, it should be limited to that which is rationally based on their perception and helpful to a clear understanding of their testimony. Most of her testimony is either merely regurgitating the hearsay documents that she is proffering, or seeking to provide some sort of analysis of those, whether in the form of legal analysis, hydrological, geological, or historical analysis without any proper foundation. Her testimony proffered on behalf of Story of Stuff is largely similar to the declaration proffered by Ms. Doty, in that it describes where she has obtained documents. She does not provide a proper foundation for the admission of any of these documents. All of them, like with Ms. Doty's documents, appear to be proffered merely for their hearsay value to prove the truth of the matter of those documents. Some of those documents are in the form of technical studies without proffering the expert for cross-examination or providing sufficient documentation to ensure the veracity or to allow for the confirmation of the details provided therein. She offers in a few short sentences, which we could delineate her testimony to strike out all of these types of opinions as to the legal import or hydrological or hydrogeological import of those documents without a proper foundation of her expertise. And similarly, we had provided the same types of objections to Mr. Lowe's testimony, which again, he has proffered two sets of testimony, his independent testimony, in which he is not identified as an expert. And then on behalf of Story of Stuff, who has identified him most currently as an expert on historical flows. His expertise, declared expertise, was changed throughout the course of this proceeding. And in the most recent notice of intent, they identified him as an expert on historical flows. Contrary to your November 17th order, they did not proffer a separate document laying the foundation for his expertise. In his testimony, he describes his experience as a biologist without laying a proper foundation for his opinion testimony proffered in relation to the documents he offers. And then all of the documents he's offering to a testimony, again, appear to be proffered for the purpose of establishing the truth of the matter asserted in those documents without establishing a proper foundation to do so.
All right, does that conclude your summary of your?
That is my brief summary, yes. Thank you.
All right, so I'm going to read over that motion. I'll take a break and read that over. But Ms. Doty, before I do that, would you like to respond?
That was quite a bit to respond to, but with regard to Mr. Lowe, we had sent and qualifying him as an expert. I don't see the need to do that twice for his personal case and for this case, if he's an expert for purposes of this trial on the matters in his evidentiary statement, then he should be an expert in both of the cases in chief. And we had sent a letter saying that we had qualified him in his declaration, inadvertently overlooking the requirement to put it in a separate document, and had offered to put it in a separate document and have been told that wouldn't be necessary. So of course, we're willing to put the same content in a separate document if that is necessary. With regard to hearsay, many of the documents are quite old. So evidence rule, 1331, evidence code section 1331 should apply with regard to ancient documents for the overwhelming majority of the documents that are from the 1950s back, which is what a lot of these documents are. With regard to the scientific reports that we have offered, quite a few of them are business records. They are reports that were prepared in order to that by either BTB's predecessors or by Forest Service personnel in preparation to support preparation of the special use permits that the Forest Service has issued over the years. And in that sense, they are business records, but they're also potentially statements against interest because they're prepared by BTB and they are contrary to the current position of BTB with regard to the nature of the water in the area. In terms of relevance, most of the documents are clearly relevant on their face. They regard either the land use history in Strawberry Canyon and at the base of the mountain near where Arrowhead springs are, or they are scientific reports specifically about Strawberry Canyon watershed. There was a lot in that statement. I believe I've hit on most things. If there is anything else that I have neglected to address, I would be happy to do that. With regard to my statement, the table did include brief statements of relevance. And largely that was just saying where the documents came from. So very simple authentication. They came from FOIA requests sent to public agencies and Public Records Act requests. Many of which BlueTriton brands had the opportunity to look over and objected to. And I submitted an earlier declaration with regard to that. So there's no element of surprise there, and their authentication their authenticity should be beyond question for BlueTriton brands in particular, because a lot of the documents that we have were, again, prepared by them or their predecessors in interest.
All right, Mr. Lowe, your hand is up. Please go ahead.
Yes, I think it would be good to check, because I'm almost positive that you've ruled twice before when they tried to get us out of being able to say anything. I think you ruled, no, we're going to let Mr. Lowe, we're going to let Ms. Doty, we're going to let Amanda Fry go ahead and speak and say what they have to say. So please check that. She made it sound like you hadn't decided anything. And I know twice before you addressed that issue. So thank you very much.
All right, thank you. Ms. Grady, your hand is up. Please go ahead.
Thank you. I first want to say I have not misrepresented anything to Mr. Lilly. With respect to the folks that are scheduled to testify today, you have reserved on that and had not made a final decision on those issues, and particularly with respect to the documents. With respect to hearsay, Rule 1331 allows for ancient documents to not be made inadmissible by the hearsay rule if the statement contained in the writing has since been generally acted upon as true by the persons having an interest in the matter, It is the burden of those proffering documents to articulate the basis of each, and these sweeping general statements that everything is essentially good enough without identifying any documents or laying a proper foundation when everybody had an opportunity to provide written submission and testimony is improper. And I will also reference again the same objection I raised before, which is that we seem to be allowing the record to be papered with documents that are not cited by anybody in any testimony. And the approach seems to be, with all due respect, a throw everything in the pot allowance, such that should this matter be reviewed by a court or even by the board, it will be impossible to determine what has actually been used and relied upon for purposes of determining the support in the record. I think, unfortunately, this has spiraled a bit out of control, and I do not disagree with, nor does BlueTriton disagree with, allowing the public to participate, but simply allowing, and this goes back to the conversation we had about, for example, the cases, which are case law, and typically you identify those with your closing brief if they need to be included, but instead we're just pouring everything into the record at this point, which nobody's testifying about. There's no explanation as to why this is relevant, and instead seem to just be tossing every single possible document anybody can find at any given point in time into the record, such that we've created something that's absolutely indiscernible upon appeal. And it just seems incredibly improper.
Mr. Lilly, may I respond to that?
Yeah, okay. Well, wait a minute, Ms. Doty, I will let you respond, but Ms. Fry's hand was up first. So Ms. Fry, please go ahead.
Yes, I am a member of the public, and I did source every document and authenticate every document, which are public records.
All right, thank you. And Mr. Lowe, your hand is still up. Did you just not take your hand down? Okay, so Ms. Doty, please go ahead.
So it's very difficult to respond specifically to these objections when the objections are made wholesale to our documents. We did attempt to do that in writing, giving examples of documents and why they are relevant in response to the first two iterations of this motion in limine that's been made again. So that addresses Ms. Grady's latest point. I realize I neglected to address Ms. Fry's proffered testimony, and I wanted to do that. Ms. Fry has set forth in her declaration that she went to the archives and collected vast numbers of documents. She then gave those to the water board, and the water board has relied upon those documents. And those documents show plans, they show directions. For example, they're documents from W.P. Rowe, who was hired by BTB's predecessor in interest. And then they actually built what he suggested building. And so it's very clear that the things that he wrote in those documents are things which were relied upon by BTB, who has an interest in the matter. And many of the documents that Ms. Fry is going to present are of the same nature. So I'm happy to go through the documents. I believe we did that in, first of all, in my statement, brief statements of relevance were given. And then in the, and also the documents were addressed, many of them in Ms. Fry and Mr. Lowe's written testimony and can be today. And then our motion before was for equitable treatment. And if you'll recall, even BTB relied upon newspaper documents that bore the handle of Ms. Fry. And again, the hearing, the prosecution team has relied upon documents that were sent in by Ms. Fry. So everybody wants to rely on Ms. Fry's ability as a researcher for documents that they find beneficial to get in. But Ms. Grady would like now, I think, to exclude every bit of the evidence that we have proffered to put in, even if it's already come in through their own evidence and the hearing boards ultimately from the same source, which is largely Ms. Fry.
All right, thank you. So Ms. Fry, your hand is up. Do you have something further to say?
I just wanted to point out again that the prosecution team used much of this evidence, and it is in evidence. And actually, there is a lot of correspondence I've looked over with BlueTriton. They have the same evidence. So I just wanted to point that fact out. They are all public documents from reference sources and authenticated.
All right, here's what I'm going to do. I'm going to review the written motion in limine that Ms. Grady filed and Ms. Doty's response. And I'm going to take a break and do that right now. And then I will issue a preliminary ruling. I'll tell you, just so you all know, so you can be preparing. My instinct is to go forward with the hearing. I certainly was anticipating that when we get to the place in the hearing, probably today or tomorrow, where the parties offer their exhibits into evidence, that there will be objections, and I will rule on them at that time. So again, there's no jury here, so we don't have as strong of a concern with relevance as we would if there were an issue of the fact finder potentially being, I'll say, prejudiced by inappropriate evidence. So it's all before me, regardless of whether it comes in or not. And I think I'm capable of determining what's relevant and what's not as the process goes forward. So I want to do that. I really want to take a break and do that. I think I've heard from everybody. Mr. Lowe, your hand is up. Do you have something more you have to say now?
Well, I just wanted to say, when you review what Ms. Doty and what BlueTriton said, Amanda Fry and I also submitted a response to their request that the in limine, whatever it's called. So please look at ours at the same time. Thank you.
All right, thank you. All right, so let's take a break. It's 9:34 right now. Let's take a break until 10 o'clock. We'll see where we are then. The best thing is to stay logged in. I think my staff can stop the recording so we don't have a long blank in the recording. And you can certainly turn off your microphone and cameras. And that's all I plan to be back at 10 o'clock. Thank you. All right, it's 10 o'clock. I'll ask my staff to remove the break from the screen share, the break sign from the screen share, and then we'll get started. All right, so Ms. Diaz, I'll start with you as the court reporter. Have you been able to get your system operating?
Yes, I joined when I could. I didn't want to interrupt. I just jumped in.
All right, well, we took a break from 9:35 till 10 o'clock, so hopefully
Yeah, I
that will
started
mean.
before that.
Okay,
Thank
good. All right, good. So I hope you can get the first few minutes into your transcription and go from there.
I will definitely do that. Thank you.
All right, so I have re-reviewed the motion in limine that BlueTriton filed on January 7th, and the oppositions filed by Ms. Doty, Mr. Lowe, and Ms. Fry, and considered the arguments that were made this morning. And here is my ruling for how I'm going to proceed. First of all, I think it's important for all of us to remember that this proceeding is not governed by the rules of evidence, not specifically or not all of the rules of evidence that apply in court proceedings. The guiding principle for rules of evidence in this proceeding is Government Code Section 11513, Subdivision C, which I'm going to read because I think it's important for us all to remember this. That statute states, the hearing need not be conducted according to technical rules relating to evidence and witnesses, except as hereinafter provided. And I will get to the hereinafter provided. I'll go on. The statute states, any relevant evidence shall be admitted if it is the sort of evidence on which responsible persons are accustomed to rely in the conduct of serious affairs, regardless of the existence of any common law or statutory rule which might make improper the admission of the evidence over objection in civil actions. That's the end of my quotation of Subdivision C. So considering that rule, there are a couple of different points, 4 different points I want to talk about. First of all, there have been some concerns here expressed about authenticity of the documents. And my conclusion is that there are no legitimate concerns about the authenticity of the documents, particularly the numerous documents that Ms. Fry has obtained from historical sources, and her declaration describes how she did that. I don't think there's any question that these documents are in fact what she says they are. In other words, if she says, I got these from the historical records at California State University, San Bernardino, there's no question in my mind that she's telling the truth about that, and that authenticates those documents. Some of them are from other sources as well, Forest Service and so forth, but I think for all 3 witnesses, Ms. Doty, Ms. Fry, and Mr. Lowe, actually does not apply to Mr. Lowe. I don't think, well, I can't remember if he submitted any documents that he obtained, but in any event, all of the documents have been properly authenticated. Secondly, I'm going to go to the question of expert testimony, and I do agree with Ms. Grady that Mr. Lowe and Ms. Fry, to some extent, their written proposed testimony may cross the border into opinion testimony, which is normally reserved for expert witnesses. And under Government Code Section 801B, witnesses with specialized knowledge may use their specialized knowledge to develop and testify to opinions. Now, Mr. Lowe and Ms. Fry did not provide separate statements of their qualifications as was provided for in the notice of hearing for this matter, but particularly regarding Ms. Lowe, there had been a request from Ms. Doty's office or inquiry as to whether or not a separate statement was necessary. And I ruled at that time that it was not, because his expertise was described in his written proposed testimony. And even though there was not a similar request from Ms. Fry, I do rule that to the extent her testimony contains expert opinion, that her written proposed testimony does describe an adequate basis for her specialized knowledge, particularly effectively her historical work to obtain those documents. But again, I want to emphasize Government Code Section 11513 Subdivision C provides the applicable standard here. And to the extent that Evidence Code Section 801 Subdivision B has a narrower rule on what's admissible expert opinion testimony, it does not apply here. And I believe that, or I conclude that the testimony of Ms. Fry, Mr. Lowe, and Ms. Doty for that matter, all does meet the standards of 11513 Subdivision C. The next question is relevance. I do share Ms. Grady's concern that about the sheer number of documents. The prosecution team submitted several hundred documents, which Ms. Grady and BlueTriton did not object to. Ms. Fry and Story of Stuff Project have submitted hundreds of additional documents, some of which overlap documents the prosecution team submitted that have already been admitted, but many do not. And I was going to provide a warning to the parties about this when I got to the point of closing briefs, but since the issue's been brought up now, I'm going to point it out now, and if I can, I will emphasize it later. My office and I simply are not capable, I don't think, of going through the hundreds and hundreds and hundreds of exhibits. And we will look at the table of contents, table of exhibits, and look at the ones that we believe are relevant to our decision-making process. But it's up to the parties to cite in their closing briefs, and we will have written closing briefs in this matter, the documents that they believe are relevant to their arguments and to demonstrate that they are relevant to the hearing issues. So it's a warning to everyone. Please do not assume that we are going to independently cull through all those documents. It's tens of thousands of pages. We do a good job. My staff does a very good job. I've said that before, and I will say it again, and I wholeheartedly believe that. But we can't find everything that you may believe is relevant in your exhibits, so it's up to you to do that. Next, hearsay. Government Code Section 11513, Subdivision D, and remember I said in Subdivision C, it said except as hereinafter provided. I think D is part of the hereinafter provided, states that hearsay evidence may be used for the purpose of supplementing or explaining other evidence, but over timely objection shall not be sufficient in itself to support a finding unless it would be admissible over objection in civil actions. Any objection is timely if made before submission of the case or on reconsideration. So this is what I'm going to do. For the limited purpose of parties objecting to other parties' evidence as hearsay and considering the statute I just read, Subdivision D of Section 11513 of the Government Code, I am going to allow time for parties to file written objections to exhibits that other people have cited in their closing briefs. So let me just tell you chronologically how this will work. I will specify a deadline for parties to all file their closing briefs, and then I will allow a certain number of time, probably a couple of weeks, for parties to file objections for the limited purpose of stating objections under 11513 Subdivision D. If somebody thinks somebody has cited a document that is hearsay and not admissible over objection in a civil action, and that it's being used in and of itself for supporting a finding without basically without the support or corroboration from other evidence, then the party may raise that objection. So that can be done before the matter is submitted to my office for preparation of our proposed order. I do note that there are several hearsay rule exceptions that may apply to many of the documents that are at issue here. And I'll state the ones I noticed. There very well may be others, but admissions of a party under evidence code 1220 through 1222, the business records exception, which is evidence code section 1270 to 1272, the official records exception in evidence code section 1280, and the ancient writing exception in evidence code section 1331. So again, I recommend that if parties are relying in their closing briefs on documents that may be hearsay and they believe that one of these exceptions applies, they should probably state that, they should state that in their closing brief. And then other parties who disagree may lodge their objections in the subsequent filing. So I'm going to turn now briefly to BlueTriton Brands January 7, 2022 motion in limine. Excuse me, let me get a drink of water first. I'm looking at this motion, and the first section, the first argument section on pages 3 through 5 argues that various exhibits are not relevant. Regarding Ms. Doty's written proposed testimony, the objection seems to be, well, part of it is that they did not lay a foundation of the documents, and I believe that proper foundations have been laid. And then the other is on relevance, and that appears to be on the basis that the documents were not provided to the State Water Board's prosecution team. That's what it states at the top of page 5 of the motion. And I've previously ruled that there's no requirement documents that are offered into evidence in this hearing have been previously submitted to the proposed prosecution team. So to the extent the motion is based on that, I have previously ruled, and I reaffirm my ruling that objection is overruled. And as I say, I believe Ms. Doty has established a foundation. I think her written proposed testimony goes into quite a bit of detail as to how she obtained these documents and basically has authenticated them. Of course, relevance is a separate issue that we need to address. The motion in limine referred to Mr. Lowe, one exhibit, SOS 262, which I believe is a newspaper article, and we can address that when assuming Ms. Doty offers that exhibit into evidence at the end of her case, in chief, or after we've completed witness examinations. BlueTriton may raise that objection, and I will rule on it at that time. I think the next part of the motion in limine argument, part B, which was on pages 5 through 8, has to do with the fact that the various exhibits were not submitted to the prosecution team before the deadline, and I've already ruled that is not a requirement. So that the motion is denied to the extent it raises that issue. And then on pages 9 through 11, 11 concerns Mr. Vasquez, who's no longer testifying, but pages 9 and 10, who already has testified. Pages 9 and 10 concern Mr. Lowe and Ms. Fry. And as I've previously ruled, but just earlier, a few minutes ago, I believe that Mr. Lowe and Ms. Fry do have specialized knowledge and therefore are qualified to provide expert opinions within the scope of their specialized knowledge, certainly as authorized by Government Code Section 11513 Subdivision D. And it appears they also would qualify under Evidence Code Section 801 Subdivision B, even though it does not appear that that is a statutory requirement here. So with that, I think we're ready to proceed. As I said before, parties will have opportunities to object to exhibits when other parties, presumably primarily BlueTriton, will have opportunities to object to exhibits when Ms. Fry, Ms. Doty, and Mr. Lowe offer them into evidence, although there will be no need to repeat the objections that I've already ruled on, that I've already overruled. And then, as I say, I do have a process that I plan to follow for objecting the use of hearsay evidence under Government Code 11513 Subdivision D after closing briefs are filed. So I'm ready to proceed, but I will allow Ms. Grady, your hand is up. You have a comment that you would like to make now.
Thank you, Mr. Lowe. Just getting a little feedback. That sounds better now. Just to clarify, there are a couple issues that were not touched upon. We had raised objections to Ms. Fry's testimony and documents detailed on page 7 through 9, which you didn't touch upon in your colloquy just now.
Oh, well, that's all under the overall heading in Subdivision B of your motion, which starts on page 5, which reads, the State Water Board's case should be limited to public comments submitted within the declared time frame. So,
okay. Thank you for clarifying that point. I just want to make sure we hadn't skipped it over. The second.
Yeah, go ahead. Excuse me. It looks like your motion on page 7 also talks about the relevance. I had taken that to mean relevance based on the argument that the documents had to be submitted to the prosecution within a certain time frame. If there's some other relevance argument, you can raise it, but I don't see any other relevance issue here.
Okay, the relevance detailed in the motion, the written papers, were that she didn't discuss when she obtained these documents at all, or that she obtained them after 2021. But I hear that you have denied the objection to those pages and just wanted to make sure that those issues were not being overlooked.
So just so we're clear, to the extent the objection is based on the argument that Ms. Fry did not provide these exhibits to the prosecution team on any date, the objection is overruled.
Yes, and that she has not, we had objected on the basis that she laid no foundation for them whatsoever.
All right, that is a separate objection. And I think I'm not going to rule on that now. I think that is something that if you still believe that's appropriate after she's testified, you may restate that objection. Again, maybe you should just tell me what you're saying here, because I don't understand this at all. I mean, I think she laid a very good foundation, described in detail everything she did to locate, download, copy these documents. So, I mean, foundation to me really largely has to do with authentication, but is there something I am missing here that you believe is an appropriate objection?
Yes, as detailed on page 7 under number 4, we stated Amanda Fry identified the following documents in her testimony presented on behalf of Story of Stuff, which she either does not discuss when she obtained them or states that she obtained them in 2021. So it was the does not discuss when she obtained them. And we had gone through the paragraphs and individual documents on the following pages.
Okay, so to the extent the objection is she does not discuss when she obtained them, the objection is overruled. I don't understand why it matters at all when she obtained them. If she obtained them and has authenticated them, then I don't understand any objection on that basis.
The next issue is that you referred to Ms. Doty's testimony. And for purposes of clarifying the record, my understanding is Ms. Doty is the attorney for Story of Stuff, and she is not identified as a witness. And that was one of the issues we raised. She presented a written statement declaring information about documents, but she's not identified as a witness. And we never quite understood the purpose of the document she submitted on December 17th.
Just a minute. Okay, I do see here that Story of Stuff Project's notice of intent to appear form lists 4 potential witnesses, and Ms. Doty is not one of them. So Ms. Doty, do you care? Please address this issue of the fact you have now submitted written proposed testimony, even though you were not listed as a witness in Story of Stuff Project's notice of intent to appear form.
Mr. Lilly, that was an oversight on my part that I wasn't listed because I don't offer any substantive testimony. It's completely document custodian type of testimony, and it's limited to, I received these documents in response to FOIA requests made on behalf of my client to the U.S. Forest Service and to the Forest Service's Office of General Counsel and to the State Water Resources Control Board. And then it has a description of the document that describes it in sufficient detail to say why it's relevant, but that's it. There's no other testimony. And,
All right.
and so I frankly was not thinking of myself as any sort of substantive witness.
All right, so the hearing notice did require all parties to identify their witnesses. However, I am, as exercising my discretion as the hearing officer, I am going to overrule that objection and allow Ms. Doty's testimony to come in for that purpose. I don't think there is any prejudice to BlueTriton. The written proposed testimony of Ms. Doty was uploaded on December 17, and I did allow BlueTriton additional time. That's why we delayed the hearing, this part of the hearing, until now. So BlueTriton has had ample opportunity to review that written proposed testimony. So even though there was a non-compliance with that provision of the hearing notice, I'm going to allow Ms. Doty to testify. Again, other objections still may be appropriate, but I'm going to allow her to testify and overrule that objection. So Ms. Grady, is there anything else in your motion that you believe I have not covered?
2 other things, and one, just to clarify what you just said. So are you now inviting Ms. Doty to provide oral testimony that we have not scheduled at all?
My ruling is that to the extent you objected to her submitting written proposed testimony and then authenticating it during the hearing today and providing an oral summary of that, I am overruling your objection.
Okay, I'll be candid. I'm completely confused because we have never once discussed Ms. Doty as providing oral testimony. So I'm just trying to understand what our game plan here is on behalf of.
Well, wait. I'm sorry, but that's a really inappropriate characterization of the record. As I just said, Ms. Doty uploaded her written proposed testimony with Story of Stuff's other exhibits on December 17. Month and a half ago. And I think it was very clear from that point on that she was planning to authenticate that written proposed testimony and provide an oral summary of that. So to the extent you are characterizing her testimony or this process otherwise, I disagree.
Well, respectfully, we have gone through the order of witnesses repeatedly, and I will review the entirety of the record. And with all due respect, Mr. Lilly, I have never once heard her name listed as somebody intended to provide oral testimony and raise the issue of my confusion in this written motion in limine before any of the oral testimony began. I'm not trying to argue with you or be disrespectful. I'm just trying to understand for our client, because my obligation here is to defend them against the action brought by the state, and we don't even know what's happening on any given day.
Well, Shortly after, excuse me, I'm not sure when it was, but before the hearing began, my office sent out a notice that said we were labeling Ms. Doty's written proposed testimony as Exhibit SOS 29 because it had been submitted but had not been given an exhibit number, which was something our hearing notice required. So at least from that point forward, I think there was pretty clear notice that she was going to be allowed to, number one, authenticate her written proposed testimony, and number two, provide a summary of that. So, I mean, we can go back and forth, but I disagree with your characterization. I think there was pretty clear notice, at least from that point forward, if not earlier, that she was going to be testifying.
I think we'll just have to agree to disagree. The last issue I had was with respect to Ms. Fry. It sounds as though you just independently identified and qualified her as a witness, as an expert witness, when she is not identified either by story of stuff or by herself on the notice of intent as an expert witness for any purpose.
I think that mischaracterizes what I said. What I said was, to the extent her written proposed testimony includes any opinion testimony, and you objected to that, I'm overruling the objection on the grounds that she is authorized under Government Code 11513 Subdivision C to provide that testimony.
As a lay witness?
I just will say under 11513 Subdivision C, she is authorized to provide that testimony. And to the extent it has opinions in it, she is authorized to provide it under that statute.
So can we clarify for the scope of the record what extent to which she will be providing opinion testimony? And I'm not trying to be difficult or fight. I just think that it's very important for the record to be able to understand the scope of what she's permitted to provide opinion testimony upon, and whether that goes into what would be qualified as expert, or if it's lay testimony based upon her observations and what is beneficial to the hearing officer based thereon.
To the extent her written proposed testimony contains opinions in it, I'm overruling BlueTriton's objections to her providing that opinion testimony.
So during the course of her testimony, would you like me to verbally object each time she offers legal analysis or opinion regarding hydrological issues, hydrogeological issues, geological issues, or historical information without a proper foundation? Or will you accept a standing testimony on those issues and state that you've already overruled them all?
If you have specific objections to specific opinions based on specific areas of expertise or lack of expertise, you should make those objections when she is testifying. But you do not need to object on the overall ground that she is providing opinions in her testimony.
Okay, I just didn't want to unnecessarily interrupt if you preferred otherwise.
Okay, I hope my ruling is clear on that point.
I believe it is. Thank you.
All right, anything else? So let's go forward. And again, I have to just shuffle papers around here a minute, but we will proceed with Ms. Fry's case in chief for Ms. Doty's request that Ms. Fry go first. So just give me one moment here. You don't need to sign off or anything. I just want to move papers. Okay. Just so you all know what I have in front of me, since I'm old school and still do things with paper, I have in front of me declaration of Amanda Fry, which, and I need to find out. Mr. Anderson, can you tell me, I know we gave this an exhibit number. What exhibit number is this if you have it? Otherwise I can look it up.
I haven't assigned it a number yet.
All right, just a minute. I'll see if I can find it too. I know we gave it, I believe we gave it an exhibit number. See who can get there first.
I believe it is Fry 151.
Okay, that is correct. I'm not sure. Was that you, Ms. Doty?
That was me, yes.
All right, so we have labeled the declaration, which we are treating as Ms. Fry's written proposed testimony, as Exhibit Fry 151. I also have in front of me Ms. Fry's revised exhibit list and then her corresponding exhibit table, which has where her exhibits all listed in there where they correspond to story of stuff exhibits and prosecution team exhibits. So with that, Ms. Fry, are you there? Where are you? There you are. Sorry, I've got to look around to my tile. Ms. Fry, please raise your right hand. Do you swear that the testimony you give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes.
All right. I'll just help you out since you don't have anyone who's representing you in the part of this proceeding where you're appearing as your own party. Is exhibit what we have labeled as Fry 151, which is declaration of Amanda Fry supporting the cease and desist order against BlueTriton Brands, Inc. for unauthorized water diversion and use. And again, that's the title. I'm not saying whether or not that's true. Is that in fact your testimony for this hearing?
Yes.
All right. And you may summarize your testimony. And again, I have read it in detail, and you don't need to repeat it all, but I am giving parties up to 45 minutes to provide a summary. So if you want to, you may summarize it and we will proceed. So please go ahead.
Okay. I'd like to start with my opening brief.
Oh, and my apologies. Okay, so let's make sure we're clear on this. I know you're trying to learn a lot of legal rules here, and frankly, you're doing well, but it's complicated. You're allowed 5 minutes for an opening statement, and thank you for reminding me. Even though you just took the oath, your opening statement is not testimony under oath. It's just argument, and usually people use that to provide a summary of what they're going to testify to. So please make that distinction very clear in your mind. And I will give you 5 minutes for your opening statement, and then we will allow you to, you have already authenticated your testimony, but I will allow you to summarize it. So please go ahead. My mistake.
My name is Amanda Fry. I live in Redlands, California. About 15 years ago, a retired district attorney and former real estate fraud prosecutor taught me how to research corporate filings, property deeds, and chain of title records. In the past, I worked at a survey office where I became familiar with surveys and legal descriptions. I am also an author, a registered dietitian nutritionist, and a food scientist. Over the last 7 years, I've conducted unpaid independent research investigating the matters in this case regarding the water rights, the history, and the springs, and the unauthorized water diversions in Strawberry Canyon by BlueTriton Brands, Incorporated, and predecessors. I have submitted these documents as evidence for the public can't compete with corporate deep pockets and their legal teams. I have hiked Strawberry Canyon headwaters many times, observing the dewatered Strawberry Creek and BlueTriton's pipelines and spring diversion sites. I support the State Water Resource Control Board's adoption of the cease and desist order against BlueTriton Brands Incorporated for the unauthorized diversion and water take in Strawberry Canyon headwaters in our San Bernardino National Forest. The San Bernardino National Forest was founded February 25th, 1893, to conserve and protect our watersheds. The forest waters were reserved upon founding, and there is no surplus water, given the arid nature of Southern California and drought conditions.
One moment, please. One moment.
Oh, okay.
Could you please try to slow down?
Yeah, Ms. Fry, imagine if you were trying to take all of this down with a transcription machine. So turn it down to it in low gear, about 75% as fast. I know when people read, they have a tendency to read fast, so please avoid that tendency.
Okay. Any valid claims within the forest boundaries had to be made in 1894. Neither BlueTriton nor their predecessors have owned land nor water rights in the San Bernardino National Forest, Strawberry Creek headwaters, Township 2 North, Range 3 West, as the San Bernardino National Forest owns the land. It's public land. In 1930, BlueTriton's predecessor, California Consolidated Water Company, encroached into the forest's Strawberry Creek headwaters and started diverting spring water from Strawberry Canyon with neither a valid water right nor a state appropriation diversion permit. This encroachment occurred before the Del Rosa judgment. BlueTriton's predecessors continued diverting in Strawberry Creek spring water, expanding the water take from one spring in 1930 to building 3 spring adits tunnels and using 10 borehole horizontal wells to tap spring aquifers in Strawberry Canyon, carrying billions of gallons of the forest water down the mountain to be trucked to a bottling facility and sold back to the public as Arrowhead Mountain Spring Water. Location is essential to understanding this case. The Public Land Survey System, PLSS as it's known, is used to identify locations in the historic records, withdrawal sites, and property boundaries. BlueTriton takes and diverts the public forest water from the mountaintop Township 2 North, then pipes the water to the mountain base about 2,000 feet above sea level at Township 1 North. The true Arrowhead Springs are located on private lands below the landmark Arrowhead at the mountain base. The first Arrowhead bottled water came from Coldwater Creek near the landmark Arrowhead at the mountain base, which was a different watershed and not downstream from BlueTriton's water withdrawal from unnamed springs in Strawberry Creek headwaters. The Strawberry Creek headwater spring numbers are from BlueTriton's predecessors and are not the true Arrowhead Springs. Historic records show that prior to diversion, Strawberry Creek was a perennial stream that flowed even during dry months, with headwater springs feeding a vibrant flowing creek lined with scrub oak, chamise, alder, dogwood, cedar, sycamore, willow, ferns, bay laurel, and thimbleberry. Prior to diversion, Strawberry Creek was used for recreational trout fishing. Today, Strawberry Creek has diminished flow and a dry creek bed with impoverished fauna and flora that no longer can support trout since fish need water to survive. The evidence reflects that BlueTriton has neither a valid water right nor authorized diversion permits in the Strawberry Creek headwaters, including no evidence to pre-1914 rights either. The business name Arrowhead Mountain Spring Water Company was used in the 1990s.
Wait, Ms. Fry, you got to slow down.
Okay.
You're speeding up again. How much more do you have? You are at 5 minutes.
I have 2 paragraphs.
All right. Go ahead and say them slowly.
Okay.
And after each period, when you get to a period, breathe in before you go to the next sentence.
Okay.
This goes for everybody, including me, but go ahead.
Arrowhead Mountain Spring Water Company was used in the 1990s on letterhead, permits, invoices, newspapers.
Uh-oh. I didn't mean to cut off Miss Fry. I just wanted her to slow down. We've lost Miss Fry. Let's see if she will come back here. Okay, I think she was in the waiting room. I think she's back. Hopefully she's coming back here.
I'm sorry, that something glitched there. Okay.
That's fine. We patiently waited for you. So
I'm so sorry.
I just asked you to slow down. I didn't try to cut you off. So
that's okay. I'm sorry.
Just do the last 2 paragraphs again.
Okay.
Slowly.
Okay. Arrowhead Mountain Spring Water Company was a name used in the 1990s on printed letterhead, permits, invoices, and newspaper articles for the Strawberry Canyon spring water diversions, Yet this name does not appear in BlueTriton's chain of title. Thus, the chain of title was broken. According to the Nemo dot rule, a seller cannot legally sell, transfer, or deed what they do not own. Therefore, the purchaser of such fraudulent transactions can claim no ownership title. Records reflect that BlueTriton's predecessors did not have a valid water right in Strawberry Creek headwaters and gave away possible pre-1914 water rights in the 1930s. Thus, it appears that BlueTriton's purchased only a water bottling operation. It is the purchaser has a burden of due diligence to understand what they are buying. BlueTriton and their predecessors have negatively impacted Strawberry Creek, the forest, and the people of California. My hope is the Administrative Hearing Office recommends a cease and desist order be issued for BlueTriton brands with maximum fines and penalties since diversions have occurred during critically dry years. So Strawberry Creek can flow with headwater springs restored for our forests, the people of California, and the surrounding communities. That concludes my opening statement.
All right, thank you. And then again, just so the record is clear, that was all argument and not testimony. So it certainly is, it's basically your policy arguments, and I'm glad to hear them, but neither you nor anybody else may cite those as testimony or as evidence that it's been admitted into the record. So with that, we now will turn to your written proposed testimony. And Ms. Fry, why don't you just tell me before we get started, how do you plan to do this? Your written proposed testimony is 19 pages. You have authenticated it. It is now in the record as your testimony. How do you plan to summarize that, and what is your time estimate for doing that?
I am going to sort of walk through my journey on this, and I'm going to just cite references for evidence in many places, trying to point out some places will be a comparison between evidence. That's how I plan on doing it. I think that you can read, I think everybody can read the record, right, the documents. So I'm just going to try to highlight some points.
Okay, and I'll tell you, that's fine. And I have allowed other parties 45 minutes, so I will allow you 45 minutes. Of course, if you take less, that's fine. But it probably would be helpful for all of us if you can sort of tell us where you are. In other words, when you're summarizing certain paragraphs on certain pages, if you can do that, that would be helpful to us. If you haven't prepared it that way, I'm not requiring that.
I haven't prepared it that way. I will cite some of the records. So much of the record is so intertwined. It's a complicated case. That's why there's a lot of evidence. So,
all right. Well, let's go ahead and do the best you can. You are required. You are limited to summarizing what is in your written testimony.
Right.
So it's 10:44. Please proceed.
Can I say again, please slow down?
I'm sorry. I will try my best. I understand.
Yeah, I really mean it. Breathe in at least twice every time you get to a period.
Okay.
Go ahead.
The pre-conference hearing started during a severe drought. And it was during another drought in 2014 that I started receiving emails from retired U.S. Forest Service biologist Steve Lowe, addressing concerns about Strawberry Creek given the drought conditions and given that Nestle was operating on an expired Forest Service special use permit. And Mr. Lawrence previously verified that permit. Can I have exhibit FR 123, please?
Okay. We will get a post screen share exhibit FR 123. Please give us a moment. And we'll see if we can rotate it. I don't know if we can.
If you can rotate it, I hope.
Rotate.
Oh, there we go. Okay.
We'll try rotating it twice more to get it right side up. Okay, we've got it. Go ahead. And maybe he'll make it bigger too, I think.
Okay. Using the Water Board's online e-ream system, I tried to verify Nestle's water right, but neither the name Nestle.
Wait, Ms. Fry, I don't want to keep telling you this. You've got to slow down.
Okay, I'm sorry.
Not only for the court reporter, but so the rest of us can understand. I mean, you've obviously spent a lot of time preparing this testimony. We want to hear it. And if you go too fast, we can't. So please slow down.
Using the Water Board's online e-ream system, I tried to verify Nestle's water rights, but neither the name Nestle nor Nestle Waters of North America was in the system. So I had a cartographer work backwards and make a map using the e-reams database points that were listed on the expired permit around Strawberry Creek and Arrowhead Springs. The e-reams database had the name Arrowhead Drinking Water Company, and that's what you see here. It's from 2015. And also the name of the U.S. San Bernardino National Forest appropriated license, A006018, in the Strawberry Creek headwaters below Highway 18, Township 2 North, Range 3 West, Sections 30 and 31. This screenshot only contains Arrowhead Drinking Water Company. I looked up Arrowhead Drinking Water Company on the California Secretary of State Business Entity Search. And I found that this corporate listing was surrendered in 1987 and was no longer an active business entity in California in 2015. Yet the e-reams system listed the wells to Arrowhead Drinking Water Company that surrendered its rights to conduct business in California. Okay, you can take that down.
Okay, Mr. Wooldridge, please take that down.
The business name Arrowhead Mountain Spring Water Company is handwritten on the 1978 expired permit and was in the 1990s U.S. Forest Service records, documents. It's printed on letterhead, correspondence, invoices, and even found in newspaper articles showing the exportation of our water to Japan.
Hold on a second. Miss Grady?
Can anyone hear me at all?
Yes.
No, we can hear you.
Mr. Lilly, okay. So I had stated an objection and didn't hear any response whatsoever.
Okay, I don't think we heard you before, but we can hear you now. So please go ahead.
And then I was speaking, so I may have just missed the entirety of what Ms. Fry just said now. I was texting somebody saying that I don't think anybody can hear me.
Okay, well, go ahead and state your objection. We can hear you now.
I was objecting to her statements to facts not in evidence and regarding and identifying a legal opinion regarding basis of rights and basis of entities.
All right. So I'm not sure what
from there forward.
What do you mean by facts not in evidence? Do you mean it's not in her written proposed testimony, or it's not otherwise in evidence?
Both, to the best of my recollection. I believe she was making assertions regarding the basis of predecessors and interest to BlueTriton brands as far as their legal status at any given point in time.
All right, so I'm going to overrule the objections. Ms. Fry is not a lawyer. I don't think she's ever participated in one of our State Water Board hearings before. I think she's doing the best she can. To the extent her summary is going beyond the specific details of her written proposed testimony, I'm going to allow it as long as it's within the general area of what is in her written proposed testimony. As far as the objections as to whether or not she is qualified to state opinions on legal matters, I'm going to overrule those objections on the grounds that based on her extensive research, she is entitled to give these opinions. Now, as far as what weight I or the State Water Board will give them, that is another question. Since she's apparently not qualified as a lawyer to give with the requisite knowledge for legal opinions. They may not have a large amount of weight, but I'm going to allow her to testify because I do believe she has some knowledge sufficient to testify. So with that, the objection is overruled. Ms. Fry, you may proceed.
Okay. May I have exhibit 149, please?
All right, let's post FR 149 on the screen, please. All right. We have 149, the first page on the screen.
Okay. We'll start with the first page. I have hiked the Strawberry Creek watershed many times over the last 7 years with many different people. The headwaters appear as a basically dry creek bed lined with a series of vaults and pipelines, no continual creek flow, and no visible natural springs expressing at BlueTriton's diversion sites. The Water Resource Institute houses archived documents related to Strawberry Creek and headwaters, including W.P. Penrose's field notes, reports, and communications from the 1930s through the 1940s, which document Strawberry Creek and the headwater springs prior to diversion. In 1930, prior to diversion, field notes from engineer W.P. Rowe described flowing springs and a flowing headwater, Strawberry Creek, lined with trees, vegetation that are not existent or sparse today.
Objection.
Today,
Go ahead, Ms. Grady.
Object to her recitation either as hearsay or seeking to interpret documents that are not otherwise yet admitted into evidence. And we have objected to those documents as well.
All right, the objection is overruled. I'm going to allow her to testify as to the documents. Our normal process is to accept offers to admit exhibits into evidence at the end of a party's case in chief. So I normally allow, and I will allow Ms. Fry to testify as to exhibits that she has offered into evidence, even though we have not yet ruled on their admissibility. So Ms. Fry, you may proceed.
Today, the appearance of Strawberry Creek headwaters and spring sites are much different than what was described in Rowe's 1930 field notes and reports. From the field notes and reports, we know that the first spring diversion started around August 1930 by California Consolidated Water Company, and the diversion was only from one spring, Spring 2. Rowe's July 3rd, 1930 field notes describe the natural spring sites and how much water was in Strawberry Creek headwater ecosystem prior to diversion. Okay, so here we are at page 1. On July 3rd, 1930, Rowe described the highway spring. This is San Bernardino National Forest, application 6108. And this spring was described as being developed by digging into rock. The highway spring flow was described by Rowe on July 3rd. Water runs down the top of bedrock and comes out under boulders. And he recorded the flow at that point as 5 gallons in 74 seconds, making note that in May, it was 5 gallons in 60 seconds. Now this headwater spring is barely wet. And now the diversion pipe, you can see there, wrapped in duct tape, dribbles water into a creek a few feet away. It's just a few feet away from the natural spring site. Finding this U.S. Forest Service highway spring, application 6108, was the first time I saw any natural spring flow in the Strawberry Creek headwaters. The flow was small, but it was enough to supply some water for the headwaters of Strawberry Creek for a few yards. In October 2016, I sent a FOIA request to the U.S. Forest Service for documents relating to this highway spring, application 6108, permit 3344. The original appropriation permit was obtained in 1928. to divert water for use along highway and a drinking fountain at the Red Rock Wall Overlook. The diversion permit was for 6.25 gallons per minute or 9,000 gallons per day. U.S. Forest Service reports indicate that a minimum 6.25 gallons a day from this highway spring 6108 was going to be required. Otherwise, BlueTriton's water extractions would be shut off or reduced. Based on the site visits, it is questionable if this minimum flow monitoring and water shut off is occurring. Okay, page 2.
We'll move to page 2.
The U.S. Forest Highway Spring no longer expresses under the described boulders that you can see up at the upper left-hand corner. Now there's just a dry creek bed, and below that dry creek bed and boulders is a spring box that myself and others have referenced as Spring 1. And this sits below the highway spring and the boulders. I have also seen this referred to as Spring Box 8 or 1-8 complex. I have never seen any natural flowing water at this site, only a dry creek bed. And you can see up and down the stream there. It's only dry. Okay, page 3, please. Prior
We
to
now have
diversion,
page 3.
okay. Prior to diversion, Rose notes on July 3rd, 1930, Spring 1 output was 5 gallons, 27.2 seconds. Rose notes describe Spring 1 as in a hollow below Highway Spring. Spring 1 was not diverted until 1948. And prior to diversion in April 1948, Spring 1 output was recorded as 10.5 gallons a minute. These photos are of the 1-8 complex vault down the dry creek bed from the headwater spring, boulders, and Spring Box 1. No natural spring expression. And you can see the discharge pipe. Sometimes when I've been up there's water expressing from the discharge pipe, usually not. And the bottom picture is looking upstream from about Spring 4 to that vault, and you'll see it's all dry. Okay, page 4.
All right, we now have page 4 on the screen.
Okay, July 3rd, 1930, Rowe described Spring 2 site flow as 5 gallons in 5.1 seconds. Rowe describes Spring 2 as coming out of bedrock through small crevices west of number 1 and 500 feet lower in elevation. Now there's just a vault, no natural stream or spring flow, and it's just a bird bath filled with a discharge pipe dribbling water that you can see there. Page 5, please.
All right, we now have page 5.
On July 3rd, 1930, Rowe recorded Spring 3 output of 5 gallons in 15.4 seconds and described the spring as water from a lot of bedrock and ahead farthest of Strawberry Creek. And this is all that's at the vault. The pipeline, dry creek bed. Okay, can we go to the next page, please?
Okay, page 6.
I first visited Spring 4 in December 4th, 2021. The situation at Spring 4, which is not diverted or developed, is a natural spring flow and extends a few yards downstream and then stops. Rowe on July 3rd, 1930 describes Spring 4 as quote unquote big spring, 5 gallons in 4.5 seconds. Water from one big crevice. Rowe noted that Spring 2 and 3 formed streams that flowed into Spring 4. Now, there are no streams flowing from Spring 2 or 3, as you saw, into Spring 4. Page 7, please. The first spring I ever visited was the Spring Site 7. When I hiked to Spring 7, all that was visible was a vault, pipes, and a dry stream bed. Page 8, please. In October 2017, I hiked up Strawberry Creek from City Creek Road to the Strawberry Creek east-west confluence below BlueTriton Springs 10, 11, 12. The contrast between the east and west branch was striking. BlueTriton takes water above the west Strawberry Creek branch. The west branch above the confluence was more like a stagnant wet marsh that was easy to walk through versus the untapped east branch, which was rapidly flowing with several inches of water deep, even in October. The difference between the impoverished west branch and the vibrant east branch of Strawberry Creek was visibly noticeable. Nestle's take above the west branch appears to have negative impact on the creek.
Can I interrupt for a moment again? Excuse me, Ms. Fry, sorry. I want to object to the extent Ms. Fry seems to be providing testimony comparing certain recent hiking trips with documents that she's submitted. And if she can point us to that in the written testimony, I will withdraw that, but I think that we've gone beyond the scope of the written testimony. And my second objection is to the extent we're going beyond the scope of what you, Mr. Lilly, have permitted on issues relevant to this proceeding into the public trust topics that were excluded in your November 7th ruling.
All right, so Ms. Fry, where in your declaration, your written proposed testimony, is this topic that you're testifying to right now discussed?
Well, just a minute.
And I will note, I warned everybody, and this is very frustrating to me, I'll just say, because I did warn everyone during the pre-hearing conference that summaries mean summaries. So if this is not in your written proposed testimony, I just can't allow it.
Your Honor, a portion of it, I'm sorry, Mr. Lilly, a portion of it is at paragraph 12, where she says she's reviewed Mr. Rowe's field notes, and then she lists the gallons per second at those at those locations.
You're on page 12, Ms. Doherty?
I'm sorry, paragraph 12 of
Okay.
Exhibit 151.
Okay, I did see that, Ms. Fry. I do see the discussion of Mr. Rowe's field notes, but is there anything in your written proposed testimony that talks about your personal observations?
Number 10 on page 4.
Okay, I do see that. It does talk about current conditions. I'm going to allow you to give a very brief summary because I think you really are getting beyond your written proposed testimony. And I told everyone I was not going to allow that. But I will allow you to give a brief summary, and maybe you already have, of you've testified to the difference between the flows in West Strawberry Creek, and maybe there's nothing more.
I don't have anything more on that.
Okay. As far as Ms. Grady's second objection, which is I ruled, she's correct, that this hearing would not concern public trust issues, which basically here would be issues regarding benefits of water to resources, aquatic-based resources. But I'm going to overrule that objection on the grounds that I think this testimony is relevant to the issue of the base flows that Mr. Rowe observed in 1930, and potentially to the extent that the springs have developed new water versus are actually diverting water that previously was spring flow. So I'm going to overrule it to that, to the extent it's based on that. So with that, Ms. Fry, I think you better move on to matters that really are in your written proposed testimony that you're going to summarize.
Okay. FR 29, page 1.
Okay, we'll put up exhibit FR 29 and go to page 1.
The State Geological Monument.
Wait, and
okay.
let us put it up first. And remember, slow down. All right, go ahead, slowly.
The State of California Geological Monument, the Arrowhead, which you can see on the mountain, points down to the true Arrowhead Springs. This was also referred to as the Ace of Spade by pioneers. The location is at the True Arrowhead Hot Springs, Township 1 North. And this location was known by Native American Indians, settlers, pioneers, area residents, mountain tourists, and those who have exploited the springs for security properties, hotel, leisure, and recreation endeavors. This is located about 2,000 feet above sea level, but it's a good reference point for Township 1 North. And, okay. Now, can we go to exhibit FR9?
All right, we'll put up FR9. All right, we have FR9.
Understanding the public land survey system is key to understanding the rest of this case. And the surveying system is used to identify location of real properties and that are included in this case. This includes the use of township, section, and range. A township is a north or south distance from a reference line that's 6 miles. It's made up of sections divided into 36 1 square mile sections, which can be further subdivided. And the ranges are the east-west measurement from the reference meridian point. And in this case, it's the San Bernardino meridian. So in the maps that are used in this from the Topo Atlas, the white references the private property and the green represents the national forest. Okay, can we go to FR 13, please?
All right, we'll put up FR 13.
Township 1 North. Oh,
Just
it's not up.
let us put up FR 13. It'll make it easier for
Sure.
us to follow your summary here. Okay, go ahead.
Township 1 North is at the mountain base. And we just identified that as the Arrowhead landmark is a good way to remember that. It has the historic Arrowhead Spring Hotel, hot springs, Coldwater Canyon, Indian Spring, and the landmark Arrowhead. And you can see that referenced on the map, Township 1 North. Township 2 North is near the top of the map, beneath the Rim of the World Highway 18 is where BlueTriton has its water withdrawal sites. And this is in the San Bernardino National Forest. So an easy way to remember as we go through, Township 1 North is at the bottom near the Arrowhead, and we climb to the top, Township 2. Okay, you can leave that up if you want.
So, and Ms. Fry, I'm going to just interrupt for a minute here because I was reviewing this exhibit and the others cited in your testimony to prepare for the hearing today. And who added, it looks like this is a U.S. Geological Survey base map and then some insets have been added. Who added those?
That was me. This is the Forest Service Atlas. It's authenticated in my record. because the two areas we're talking about are in two separate pages. So to make it easy for comparison, I put those together. I have the original pages are 10 and FR10 and FR11. But
Okay,
you'd have
and
to
you
keep
added this,
flipping. And I, for reference, added approximately where the Indian Springs 1929 site is that's referenced in documents 1909 withdrawal and the current withdrawal. I added those and I did put that in my notes for authentication.
all right, and is that, did you add that text based on your knowledge that you developed from your review of the exhibits that you have submitted for this hearing?
Yes, sir.
All right, you may proceed.
Court cases and sites of early water withdrawal.
Oh, are you done with this exhibit? We'll take it down if you're done with it. Or if not, we'll leave
fine.
it up.
It depends if you want to use it as reference or not for the rest.
And we'll leave it up. Go ahead. Please proceed. Excuse me for interrupting.
Okay. The early withdrawal sites were at Township 1 North, Range 4 West, based on records I found at the San Bernardino County Historical Archives. There were two court cases, the 1912-1913 Arrowhead Hot Springs versus Arrowhead Cold Springs Company, case 12532, San Bernardino County Superior Court. And it gives the Arrowhead Hot Springs property legal description in the complaint as Township 1 North, Range 4 West, Range 3 West. And this is at the base of the mountain in Township 1. The second testimony was in the 1910 case, the Arrowhead Springs Water versus Hot Springs case. And this describes the original water source for early Arrowhead water bottling was from Coldwater Creek, from springs coming off the rock of Arrowhead Mountain and Coldwater Canyon. There's repeated testimony describing those, what that looked like. So we know that the original site for withdrawal was at the base of the mountain and from Coldwater Creek. Okay. The Del Rosa judgment is how California Consolidated Water tried to obtain water rights at the current site location. The case neither mentioned that the land was of Township 2 North, Range 3 West, was located in the San Bernardino National Forest. U.S. Forest Service nor the state of California were involved in the cases. Adverse possession does not apply to federal lands. May I have exhibit FR 30, please, and page 10.
Okay, we'll go to FR 30, page 10.
I just want to quickly object. I can't find and don't recall the reference to the first case Ms. Fry referenced in her written testimony.
FR 26.
So, Ms. Fry, where in your written proposed testimony do you refer to the first case, the 1912-1913 case?
FR 26 in the exhibits.
Okay, but where in your written proposed testimony?
Mm-hmm. I'll take it.
Mr. Lilly, in paragraph 11, she talks about the original spring for bottled water, and she lists FR 26, which is that case, the Hot Springs versus Cold Springs 1912 case.
Thank you.
Okay, so it is referenced there. So I'm going to allow that testimony that Ms. Fry has already given. Ms. Fry, you may proceed. And again, I know you're doing the best you can. This is stressful, but please proceed. And we are trying to keep this to be a summary. It looks like we now have FR 30, page 10 on the board.
Okay, just a minute. This document is from the National Archives in Riverside, located in Paris, California, where the San Bernardino National Forest historic records are obtained, are housed. I obtained a National Archive reader card. This is document dated April 28th, 1966, is the State Water Right Board Memorandum concerning applications to appropriate applications within boundaries of the San Bernardino National Forest. If we go to page 10, the document. Oops.
I think
Are we on page 10?
I think we're there.
It looks like we're there, aren't we? You will notice the highway spring. Let me see, hang on. Oops. Division. Yes, I think that's the fifth one down. Okay, it's application 6108. It has a little check mark by it. And you'll see that that's the application for what they call the highway spring. And you can see the location too. Township 2 North, Range 3 West. This application was filed October 31st, 1928 by the California Divisions of Highways and later transferred to the U.S. Forest Service. There are no other applications in the San Bernardino National Forest for any of BlueTriton's predecessors. Okay. FR 44, please.
Okay, we'll put up FR 44.
So I made multiple trips to this San Bernardino County Hall of Records. And this is one of the first items I obtained. This is the 1929 pipeline survey. The maps I got for $25 a piece were very large. So sorry, I had to scan them to a smaller page. But the first thing to notice is that these survey maps are in Township 1 North. And you can tell that by the survey markers on both pages in the corners. So these maps show that the pipeline in 1929 was only at the mountain base. Okay. And I'm just going to say too, this map is referred to later on through many documents of the record. So the early history of the Arrowhead bottled water is tightly intertwined with the Hot Springs Hotel, especially since the Coldwater Creek, fed by springs off the Arrowhead Mountain, was the source of the first water for bottling. And the history of the Arrowhead Springs Hotel is in the exhibits. There's been many fires. It was rebuilt multiple times. And from 1895 until there was nothing until a new hotel was built in 1905. But recorded deeds give the location of this hotel and the proper Arrowhead Springs property at the base of the mountain, Township 1 North. since BlueTriton's interest is derived from the property and the water bottling that was first located at the base of the mountain, deeds recorded, and I'd just like to cite those, FR 2597, FR 103, FR 102, are property deeds between 1915 to 1925 for the Arrowhead Springs real property. And if you notice in those deeds, it only contains real property at the base of the mountain in Township 1 North. And the associated water rights go with the real property. FR 98, we don't have to put that up, it takes time. But in 1920 to 1924, the Arrowhead Springs Hotel was leased to the US military for veterans from the World War I that had been gassed and shell shocked. And this exhibit, the Arrowhead Springs Hotel was hoping that the government would, buy the property, but instead they returned it in bad need of renovation. But ads and articles state that the water from this time was obtained at Indian Springs, and again at the base of the mountain, Township 1 North. 1925, Arrowhead Springs property was sold, and the property and water business were used for collateral for a gold bond that was issued. The bond indenture, which is Exhibit 102, gives the property location, the real property and water rights associated with it, Township 1 North, Range 4 and 3 West. So the bond put up the water rights and the property for collateral. Okay. FR 104 is a series of agreements with the Charles Anthony, who was the water bottling manager and the vice president of Arrowhead Springs Corporation. Remember, they're entangled, they're still together. And these agreements show that Anthony was approached to sell off the water bottling company by California Consumers Company. So Exhibit 109 is a title insurance policy of what would be given to in this sale. So what Anthony agreed to. And when you read the title insurance policy, excluded anything on the US reservation, any surface rights or hot springs. Thus, there was nothing ever in Strawberry Creek and Canyon, even up through 1929. It's always been at the base of the mountain. And remember, their water bottling's at top, Township 2. FRI 106 is the notice of intended sale. It includes certain easements and water rights on the real property of vendor in San Bernardino County. And we know that those are in Township 1 North, Range 4 West, based on deeds. FRI 116 is a California Consolidated Water Incorporation papers. They were incorporated February 1929. Byron Waters was the old-time attorney for Arrowhead Springs Corporation. He's quite old by this time, but he lists in FR 108 is his letter explaining what water rights would be transferred and property rights would be transferred upon the sale to California Consolidated Water. It all sounds good, belonging to this company, whatever rights or interests, but location and boundaries are important. 109, the title insurance policy, it has exclusion and exceptions. Reservations in the US would have excluded the San Bernardino National Forest, excluded adverse possessions, excluded surface streams and hot springs belonging to Arrowhead Springs Corporation. So the clause alone would have excluded anything in Strawberry Creek, in the Upper Canyons, in Township 2 North, Range 3 West, in the San Bernardino National Forest. It also would have excluded Indian Springs, because actually that's located based on the 1929 survey map in the San Bernardino National Forest. The terms belonging to grantor are key. That's so the grantor, Arrowhead Springs Corp, only owned property in Township 1 North. And that did not include anything in the Strawberry Creek Headwaters, Township 2 North. Warranty deed, Fry 110. It's a 1929 warranty deed. That's basically a summary of the title, insurance policy. And again, it excludes all surface streams, hot springs, and only property that Arrowhead Springs Corp owned in Township 1 North. It references the bond indenture, FR 102 and FR 44, the pipeline as proof of real property. Can we just put up FR 111?
We will put up FR 111. Give us just a moment. Looks like we have FR 111 up.
This document was signed in August 1930. That is before the Del Rosa judgment, which was signed in October 19th, 1931. This agreement was taken out as to resolve disputes between California Consolidated Water and Arrowhead Springs Corporation. And this document explains how California Consolidated Water Company, BlueTriton's predecessor, gained entrance into the San Bernardino National Forest, Strawberry Creek headwaters. Go to page 2, and the third whereas, you'll see this the purpose of this document to resolve disputes. It goes through a list of how they're going to resolve this dispute. And for this, starts that Consolidated Water is going to build a pipeline to Strawberry Canyon Springs. They're going to connect with the Arrowhead Springs pipeline, 1929 pipeline. And they're also going to build a pipe to Coldwater Canyon. Then they're going to give Arrowhead Springs Corp half the water that they take from Strawberry Canyon. If you go to the third page, okay, this is the first full paragraph there. Arrowhead hereby grants to Consolidated without any warranty whatsoever, except the warranty that Arrowhead has not conveyed or transferred to any other person the same right, title, or interest, the sole and exclusive right to develop water from all sources, whatever, whether surface, subterranean, seepage, or other right in Strawberry Canyon, and whether within or without real properties now owned by Arrowhead. They grant to Consolidated without any warranty whatsoever, except the warranty that Arrowhead has not conveyed or transferred to other persons the same right, title, or interest, one half the water developed from any of the sources in Strawberry Canyon, reserving one half of such water. Arrowhead Springs Corp did not own the national forest. They never have owned the national forest, and they had no water rights in Township 2 North, Range 3 West, the national forest. This is how they entered. This is how California Consolidated Water.
So Mr. Waldridge, why don't you just zoom out one click so we can see the text on each line completely. There we go. That's good. Thank you. All right, please proceed, Ms. Fry.
The next line refers to that 1929 pipeline in Strawberry Canyon. This line was put in 1929 by Arrowhead Springs Corp. Can you scroll down?
That's good. That's good. We can read that now. Thank you.
Are you ready to go on?
Yeah, go ahead, Ms. Fry.
Okay. So
and I've read these before, so that's fine. Please go ahead.
Okay. Can you scroll down to the fifth, or it says fifth down there toward the bottom?
Okay. We've got fifth now.
Mm-hmm. Now, in consideration on the premises, Consolidated does hereby wholly release, surrender, and quit claim unto Arrowhead any rights whatsoever that would have been pertained virtue of said contracts or any said warranty deed or otherwise to surface or subsurface water consisting of Coldwater Canyon within or outside the boundaries of the real property owned. That's the first site of the water bottling where the water bottling was taken. So thus it would appear, my opinion, they gave up their pre-1914 right. Can you go to the next page, please?
Okay, we have the next page. I think this is page 3 of exhibit FR 111.
Mm-hmm. And go down to where it says 9th.
Can I remind you once more when you're reading to please slow down?
I'm sorry.
Problem we all have, Ms. Fry, but it tells you to slow down, you should slow down. So you're doing fine. Keep it up. Just take 2 breaths each time you get to a period in your testimony. Go ahead. 9th. Tell us about what you say about 9th.
And 9th, Consolidated Water deeds back any rights to Indian Springs.
Mr. Lilly, can we do a time check and maybe ask if anyone needs a break?
I think that's a good question. I would normally have taken a break by now, but we took a break from 9:30 to 10 at my request. But let's, first of all, Ms. Fry, you have hit 45 minutes on your summary. There have been a few objections, not very many though, so that's been mostly your summary for the 45 minutes. So how much longer do you want for your summary?
I have about probably 5-10 minutes left.
Okay, here's what we're going to do. I definitely want to finish your summary before our noon break. So it's 11:34 according to my clock. So let's break until 11:45, and then our plan will be for Ms. Fry to complete the summary of her written testimony. And Ms. Fry, you can take a moment here to make sure that what you're summarizing really is summaries for your written testimony, and to pare it down so it is just summary. We will come back at 11:45 and we will finish by noon. I don't want to cut you off mid-sentence, but you said 5 to 10 minutes. I'm going to give you 15, but then I really mean it. So with that, let's turn off. We'll come back at 11:45. Thank you. All right, we're waiting for Miss Fry.
I'm here.
There's Miss Fry. All right, Miss Fry, we're back on the record and you may proceed with your summary.
FR 112, I don't think we need to pull it up, but this is another agreement, September 1931, before the Del Rey judgment was issued. And again, Arrowhead Springs Corporation, again, attempts to confer unwarranted invalid water rights to California Consolidated Water in the headwaters of Strawberry Creek on San Bernardino Forest Land, Township 2 North, Range 3 West. And in this agreement is where they agreed to give the Arrowhead Springs property owners 20% of the water that they take off Strawberry Creek, which and the San Bernardino, the U.S. Forest Service special use permits require a valid water right for the pipeline conveyance system. So with each corporate sale, it's a similar story. On October 29th, 2021, Governor Newsom declared a statewide emergency drought. Even though I was hiking on December 4th, BlueTriton's pipes were still gushing with water. And even as the State Water Board determines that BlueTriton had a 7.26 acre feet, that amount of water they've taken in excess of that amount since 1947 would last into centuries. BlueTriton bought this water bottling operation with a leverage buyout, basically betting on California's water. Thank you.
Does that complete your summary of your written testimony?
Yes.
Written proposed testimony. All right, so let's, if I'd known, I would have had you do the 3 minutes before the break, but that's fine. I just want to ask, show of hands, electronically or the old way, who wants to ask cross-examination questions of Ms. Fry? Ms. Grady? Anybody? I don't see anybody else. I hope I have everybody else here. I'm just going to make sure. Oh, I've got to get into view. Sorry, I was in the wrong view. So hang on, I see Mr. Petrozelli. Just a minute here. Grady. Anybody besides Ms. Grady, Mr. Petrozelli, who wants to ask cross-examination questions of Ms. Fry? You can put your hand down, Mr. Petrozelli. I did see you. Okay, I think it's probably going to be easiest for the attorneys who want to ask cross-ex questions if we take a break and then take a lunch break and then start cross-ex questions. That might give you a little time to organize them based on what you've heard this morning. I don't know who should go first. Mr. Petrozelli, do you have a comment as to whether you or Mr. Grady should go first? No comment. Ms. Grady, do you have an opinion as to who should go first between you and Mr. Petrozelli?
I would ask that Mr. Petrozelli go first, please.
I think that makes sense just under the circumstances. So we'll take a break until 1 p.m. and then we will start with Mr. Petrozelli's cross-ex of Ms. Fry. Mr. Petrozelli, do you have any estimate for your time for cross-ex?
I think it'll be short.
Can you? I'm not going to hold you to it. I'm just trying to kind of scope out my afternoon here. What's the time estimate? Number? Minutes?
10 minutes.
All right, we'll put you down for 10, and if you go over, that's okay. Ms. Grady, how long do you think your cross-ex of Ms. Fry will go?
I expect 5 to 10 minutes.
5 to 10. All right. And I don't think I saw anybody else with his or her hand up. So that should go relatively quickly. So Ms. Doty, you will then be, then we will handle exhibits. I assume Ms. Fry will want to offer her exhibits into evidence, and we'll handle objection to those and rulings on those. And then Ms. Doty, you will be up, but we clearly will be getting to Story and Stuff Project's case in chief this afternoon. I don't know exactly when, but sometime fairly soon after the lunch break. So be ready. And Ms. Grady, your hand is up.
And I'm not going to ask that he necessarily has to, but if Mr. Petrozelli's ready, considering the time, it might make most sense for him to go ahead and proceed now. I mean, with the curious nature of the situation where we have the different parties setting forth different cases against BlueTriton, it might make more sense for us to have, we'll want a little break before our cross following Mr. Petrozelli's one way or the other, I think.
Okay, that's a reasonable comment. Because it could be Mr. Petrozelli that Ms. Grady's cross-ex questions change based on what you asked Ms. Fry. But on the other hand, if I will give you some time to get organized if you want to. So would you like to go now or would you like to go after lunch? If you have to go off mute though to tell me.
I'd like to go after lunch.
All right, yeah, Ms. Grady, I was an attorney for many years doing hearings. I know how it is. Frankly, if we give Mr. Petrozelli time, he can probably organize his cross-ex questions and they may, I hope, will go more efficiently. So let's do that and then you'll go next. And if you need a break after Mr. Petrozelli, please let me know and we'll certainly consider that. So let's reconvene at 1 o'clock. Just as a reminder, the way our Zoom and YouTube recordings go, we have a separate recording for the afternoon. So everybody should log off to this recording and then log back on just before 1 p.m. So with that, everybody have a good lunch break and we'll be back at 1 p.m.
Thank you.